In most injury cases, you will ruin your injury claim if you settle your claim quickly.
No, God! No, God, please, no! No!
To explain why, let me tell you the story of my past client, Abby. Abby was injured in a motor vehicle accident, but what I'm about to teach you in this video applies to all personal injury cases. Abby was driving straight on a 2-lane road when another driver pulled out in front of her from a side road, fishtailed, and collided with her vehicle, pushing her vehicle off the roadway into a brick sign on the side of the road. Abby was taken by ambulance to the hospital. She was discharged from the hospital the same day. Abby was clearly not at fault for the accident. Oftentimes in car accident cases, when you are not at fault for the accident, the other driver's insurance company will reach out to you to try to settle with you shortly after the accident. However, in Abby's case, and in most injury cases, it would have been a horrible idea for Abby to even think about settling her case at this point, and I'll explain why later in this video. Now, back to Abby's story. After Abby was discharged from the hospital, she soon then began getting additional medical treatment, especially for her right shoulder, which was giving her issues. She eventually had an MRI about a month after her accident on her right shoulder, which showed she sustained a tear of her rotator cuff. Months later, Abby eventually underwent surgery to repair the tear in her right shoulder. After the surgery, she had to go through a couple months of physical therapy treatment for her shoulder. It was now an ideal time to try to initiate settlement negotiations. So after my office gathered Abby's medical records and bills, I sent a demand letter to the at-fault driver's insurance company along with all of the evidence we had obtained in support of Abby's claim, including her medical records and bills. I demanded the insurance company to pay the policy limits. The insurance company delayed providing me with a response, so I filed a lawsuit. This got the insurance company's attention. After filing the lawsuit, they soon agreed to pay out their insured driver's policy limits of $100,000. But we weren't done there. Thankfully, we had additional insurance coverage we could pursue. You see, Abby was driving a vehicle that was insured with underinsured motorist insurance coverage. Underinsured motorist insurance, also known as UIM insurance, is insurance coverage that will pay for your injuries and damages over and above the at-fault driver's insurance coverage in the event the at-fault driver did not have enough insurance for your damages. So after settling with the other driver's insurance, we then pursued our claim against the underinsured motorist insurer, who we had also named as a defendant in the lawsuit I filed on Abby's behalf. After a couple rounds of negotiating back and forth, I soon realized we were not going to get a fair and reasonable settlement anytime soon from the underinsured motorist insurance company. So I continued litigating the case. And after several months of litigating the case, we finally agreed to mediate the case with the UIM insurance company. Mediation is a process that usually takes place when a case is in litigation, wherein the parties meet with an agreed upon impartial and neutral person, usually a very experienced lawyer or retired judge, who assists the parties in attempting to reach a settlement. In Abby's case, mediation was held about 33 months after her car accident and almost 2 years after I had filed the lawsuit. By that point, we had showed to the UIM insurance company that we were not backing down. We were only going to settle if we got a fair and reasonable settlement offer. At mediation, with the help of the mediator, the UIM portion of the case settled for $165,000, bringing the total settlement for Abby's case to $265,000. Abby was thrilled. And remember earlier in the video after Abby went to the hospital when I said it would have been a horrible idea for Abby to even think about settling her injury claim shortly after her accident. So why would it have been such a horrible idea? It would have been a horrible idea because the insurance company would not have given Abby any credit to any of the medical treatment or pain and suffering damages Abby incurred after she was discharged from the hospital. Not only that, but oftentimes, if you don't show the insurance company that you are willing to fight hard in your case for a fair and reasonable settlement, they will just lowball you, knowing that some accident victims will accept lowball offers rather than fighting for a fair settlement. If Abby would have attempted settlement negotiations shortly after her accident, the insurance company would have made Abby a low offer to try to make her claim go away. Even if you've sustained neck or back pain that just requires chiropractic or physical therapy treatment without any ligament tear, injury, or broken bones, or need for surgery, it is in your best interest usually to get the treatment you need before even attempting to settle your case. No one will really have any idea of the value of your case until you are done treating or at least reach maximum medical improvement, and that is why if you try to settle your injury case shortly after your accident, you will almost always be settling for a fraction of what your case is worth. But the thing is, now that you know that in most injury cases, it can ruin your injury claim if you settle fast, I will say there is a certain situation where it actually makes sense to settle your injury claim soon after your incident. And in this video about to pop up right here, I'll tell you what that situation is and the only way I know to speed up your injury claim when that situation arises. Lastly, if you've been injured in Kentucky, remember to don't wait, call Tate.